Hi there, I'm Christine, and this is the Canadian Constitution Foundation's Freedom Update. Today I want to talk to you about Canada's constitutional culture and what my friend Kris Kinsinger from the Runnymede Society has called our country's deep rot in our constitutional culture. Is there too superficial an understanding of our fundamental freedoms? And does one side of the political spectrum have a poorer conception of rights than the other? And what does this mean for our ability to hold our political leaders to account? And what can we as citizens do about it? I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, hit like and subscribe below. It really helps my videos out a lot. And if you ring that notification bell, you will never miss one of these videos. Also, please remember my videos are for your information purposes only. They are not legal advice. If you have your own legal question or problem, please consult your own lawyer. So you might have noticed I have an injury in my hand. I'm wearing this splint, and I also have a big bruise on my wrist. I was cycling on the weekend, and this teenager ran head on first into me, coming down a hill on the wrong side of the road, totally out of control. So I've been moving a little slower than normal, but I thought that this video is so important. I think that the message of protecting our fundamental freedoms is so valuable that it's too important not to share. Because what I want to talk to you about today is the poverty of our constitutional culture in Canada. This year is the 40th anniversary of the patriation of the Canadian Constitution and the enactment of the Charter of Rights and Freedoms. So it's a good time to reflect on the state of Canada's constitutional culture and on how the Charter has performed in guarding our fundamental freedoms. Now, my friend Kris Kinsinger from the Runnymede Society has written about this in a recent op-ed in the National Post, and the executive director of the Canadian Constitution Foundation, my boss, Joanna, has written about it in The Hub, an online publication. So I will link to both of those in the description below so you can go and check out those articles for yourself. But I want to talk to you a little bit today about what they wrote and what I think about it. So Kris noted that while the Charter continues to occupy a really lofty position in our national imagination, far too many Canadians have a really superficial understanding of their constitutional rights and freedoms. As an example of something that I have noticed of this superficiality is on Twitter, there's an account with a huge number of followers that tweets about constitutional law, and it posted something along the lines of, "We don't have freedom of speech in Canada, that's an American expression," which is totally asinine. Of course, we have freedom of speech in Canada. We have a Section 2B Charter protection for freedom of expression, which of course includes speech. So I don't even know what point this is trying to prove by saying we don't have freedom of speech. Of course we do. Really superficial and weak understanding of rights. Now, in addition to the lack of public understanding about our constitutional rights, Joanna from the CCF has noted that despite the protections offered to us in the Charter, our fundamental freedoms have received pretty weak protections over the last 2.5 years during the COVID pandemic. First, though, I want to talk about Kris's point about our country's impoverished constitutional culture. The pandemic has worsened a kind of absolutist conception of both freedom and of the government's power to limit freedom. And both ends of the political spectrum are guilty of this black and white thinking. On one end of the increasingly polarized spectrum are people who view any limit on constitutional rights as unjustifiable. And now look, I am a civil libertarian. I believe in very strong protections for rights and very strong checks on government power. But I also understand that our Constitution allows there to be justified limits placed on our rights. For example, I believe very strongly in the right to protest, but I also understand that not everything that happens at a protest is legal. If a protest includes, just as an example, a border blockade or a rail blockade, the police have the ability to legally clear that blockade. And in fact, I believe that the rule of law requires it. Now, on the other end of the political spectrum are people who seem to believe, or at least are ready to accept, any limit on our constitutional rights if that limit is pursued in the name of what they perceive to be a public good, or at least a government act that aligns with their political preferences and prejudices and, frankly, partisanship. Supporters of this view will frequently remind us that all charter guarantees are subject to reasonable limits under Section 1. And yes, of course, this is true. Our Constitution contains Section 1 of the Charter, which does permit reasonable limits. For those of you who aren't familiar with Section 1, it states that the Charter guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So yes, Section 1 is a part of our Constitution, but simply saying, as these rights limiting proponents do, simply saying that Section 1 exists is pretty trite. It doesn't tell us anything about what makes a limit on our right reasonable or justified. And I see this all the time on Twitter. The government will do something totally outrageous, and people will be rightly outraged. And then someone, and I'll be honest, it's usually a smug partisan who supports whichever government has done this outrageous thing, well, they'll chime in and say, oh, don't you know about Section 1 of the Charter? The government can limit our rights. As if just saying this means that that particular limit is justified. As another friend of mine, Alan Richards, has frequently said, if Section 1 is your favorite part of the Charter, you are doing freedom wrong. At an absolute bare minimum, Section 1 of the Charter tells us that democratic governance will always demand respect for a basic threshold of freedom, even if this freedom must occasionally be limited. People forget that the government bears this onus of proving why a limit is justified. Section 1 is not just like a blank check that the government can wave and say, oh, well, we're just citing Section 1, we can do whatever we want. No, that is not how it works. So I think both of these extreme polarized views are wrong. They are superficial, they lack nuance, and as I've mentioned, they're usually espoused by partisans. Partisans who use the Charter to either justify or criticize various government responses, and we saw it a lot during the pandemic. Now, my perspective personally is that while both of these views are wrong, both of these extreme views are wrong and have problems, I do tend to lean more towards the view that Section 1 has been relied on way too much throughout the pandemic to excuse, frankly, unjustifiable and unconstitutional limits on our rights. Now, this gets us to what my boss, Joanna, has written about in the Hub. First, it's important to note that in the early days of the pandemic, there was a lot of uncertainty, there was a lot of fear. There were some government responses that at the time seemed reasonable, but with hindsight, perhaps not. But what I'd like to focus on is examples of overreach that even as they were happening, so many of us saw plainly through that these were not justified limits on our rights. I'm talking about the sorts of laws that vividly and severely impacted our core liberties and even the dignity of individuals. These are things that could not just be simply swept under the rug of Section 1, and certainly could not be swept under Section 1's rug indefinitely. These are things that could not be forever justified under the government's excuse of exigent or extreme special circumstances. In particular, I'm thinking of cases where the government failed to provide compassionate exemptions for their most draconian measures. And I'll admit that at the beginning of the pandemic, I believed if a law didn't make accommodations for individuals to meet charter requirements, that courts would come in and strike down those laws under the charter. But that did not happen. And I have to say, it was not for want of trying by those of us at the Canadian Constitution Foundation. We brought a number of charter challenges during the pandemic when governments had overreached. For example, in the summer of 2021, we at the CCF, along with several individuals, brought an application against the government for the quarantine hotel measures that required all returning travelers into Canada to isolate in an approved hotel for 3 days at a cost of $2,000. The applicants in our case were all of modest financial means, and each of them needed to travel outside of Canada for a compassionate reason, like attending a parent's funeral, caring for a parent with a terminal illness, or caring for a spouse who lived outside of Canada and was unable to care for herself in that case. The expense of these hotels, $2,000 or more if it was a larger group traveling, a larger family traveling, it was really crushing for these individuals. But in addition to that, the public health justification for these hotels was really flimsy. In spring of 2021, which was even during, while this case was in progress, the federal government's own expert advisory panel recommended discontinuing the hotel program, the hotel quarantine program, because they said it was unlikely to have any effect on the spread of the virus. We thought at the CCF that striking down the program clearly followed from the charter's guarantees, if those charter guarantees of mobility, of security of person, of liberty, if they were to have any teeth. But in court, the judge summarily dismissed our claim, deriding the serious issues that we raised as what he said were decidedly first world economic problems. He didn't find any breach of any charter rights that we asserted, including the right to mobility, the right to enter your own country. This posture of what I would describe as extreme deference was the norm throughout the pandemic. Even patently absurd restrictions like bans on church holding drive-in services, even those were upheld. Now, I think it was predictable that governments, in responding to public pressure and fear around the pandemic, it was predictable that governments would probably overshoot the mark and act according to this precautionary principle when they were deciding how to set their policies. They would probably, in some instances, get that balance wrong. And if you remember, during the pandemic, nearly all of these public health measures were polling pretty high. They were popular. So it fell to judges and courts to hold up the principle from Robert Nozick that individuals have rights and there are things that no person or group can make them do. Now, the experience with litigation coming out of the pandemic related to the charter, it's not over. And maybe I seem overly optimistic, or maybe I haven't learned my lesson, but I am still feeling positive about a number of our cases that we are still waiting for decisions on that came out of the COVID era. For example, our Emergencies Act case challenging the federal government for illegally invoking that extreme legislation, the Federal Emergencies Act. I think we have a really strong case there. And I also think that our challenge to the British Columbia vaccine passport policy that did not include any medical exemptions, I also think that's a very strong case. So we are waiting for decisions in those cases, and I'm pretty optimistic. I also think that the political tide on extreme measures has probably shifted at this point. That said, I would still love to see decisions coming out of the court upholding the values of liberty. I think that that would be very reassuring to civil libertarians like me. If we were to see some liberty-oriented decisions, it could help guard against the overreach that we saw over the last 2.5 years from being repeated at some time in the future. Now, one last note about the constitutional culture in Canada and the ways that the Charter has seemed to not live up to its promise for civil libertarians. I think it is really important to remember that our freedoms are not contained solely in the Charter. There's a real tendency in Canada, in modern Canada, to mythologize the Charter as the sole source of our constitutional rights and freedoms. but it isn't. Well, obviously the Charter is important and it was a positive step in our constitutional evolution. Civil liberties were not just conjured into existence in Canada in 1982. We also should remember that responsibility for constitutional democracy in Canada requires that all actors assume that they are bound by the foundational rules of the game. It's not just the courts who are responsible for protecting our rights. It's actually the legislature and executive, our elected politicians, not the courts, who are best positioned to specify the contents of rights. The legislature and executive are in the business of directing bureaucrats, of consulting with the public, with their constituents, and of crafting proportionate responses. Judges alone cannot carry the full burden of the Charter. Our political leaders also need to respect fundamental rights. We can't just turn to the courts and say it was they alone that failed to protect rights during the pandemic. That failure began with our elected leaders. For example, when Doug Ford seemingly ignored warnings from his own attorney general of the unconstitutionality of his plan to shut down playgrounds and card families out for walks on their streets. Or of Prime Minister Trudeau, the leader of the so-called Charter Party Liberals, who illegally invoked the Emergencies Act, which took a wrecking ball to well-established rights against unlawful search, seizure, and privacy. It's not the courts alone that check this power, just as it's not the Charter alone that guarantees our fundamental rights, which of course long predate 1982 and are inherent to our humanity. As citizens, we also have the power to check the conduct of our political leaders and ensure that all public actors know that their power and conduct is limited by our rights. So when my friend Kris Kinsinger talks about the rot in our political culture, this is why it matters. If we don't understand our rights, if we have too superficial an understanding, we won't be able to do our job as citizens in holding our political leaders to account. Now, I'm not just complaining, I'm doing something about it, and you can too. We are working at the CCF to improve Canadians' understandings of our fundamental freedoms through a free online course we developed, Constitutional Law 101. You can sign up totally for free at the ccf.ca/learn, and the course explains how our Constitution is structured, how it works, and it's taught by video lecture by some of Canada's leading legal scholars and practitioners. It's self-study, so you can go at your own pace. You watch a video lecture and then complete the quizzes. And when you're done, we will send you a certificate that you can print or share on social media. So that's what I am doing to help address the rot in our constitutional culture. And you can help too by signing up at theccf.ca/learn. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.